That's my question.
So we'll get started. So during our executive session, we made no decisions, but we did receive some advice. Generally that perhaps the Rule 508 does not apply. So we have three options. And even though it does not apply, we could say we're not going to have a public forum. It's a public forum, I think. Even though it does not apply, we could have a forum, or that it does apply and we should have the forum. So I think generally whether it does or does not, I think that holding a public forum makes a lot of sense, and we should go forward with that. So I think at this stage, I think do we need to entertain a motion, or just how would you like to proceed, commissioners? We have the public forum, and then at that point we could ask Director LaForte to work to schedule something that works with staff and works for time, because I think it's also important for the commissioners, as many as possible can make it, to also show up so we can hear what the public has to say about this.
And then that hearing officer reported to the commission? Not that I don't want the commission, I just wondered how it will work.
Well, if you're willing to have us show up,
Yes, please.
we'd like to show up.
I just wanted to be clear with you.
Can I just provide a little bit of additional commentary? I think at least from my perspective, it seems like the language of Rule 508 is pretty specific in that it limits when a local public forum can actually happen. And so what I envision is not necessarily a Rule 508 local public forum, but I do think there's value in having either a hearing officer or one or more of the commissioners attend a public hearing and essentially hear public comment from individuals in the community who are so interested in this proceeding. From my perspective, I think that the reason why having a public comment hearing, even though it's not necessarily contemplated by the rules, is warranted here, is because we have been approached by the local government. It does seem that there's a really high level of interest in this particular matter. And so while not every spacing application certainly will warrant a public comment hearing, I think that this kind of rises to a level where some additional public process is warranted and I think provides some significant value. So I would propose, and I suppose I can put a motion on the table if that's useful, that I would propose that the commission hold a public hearing in Broomfield to obtain public comment on these applications. And I will offer, although not part of a formal motion, that I personally am willing to comment and be the repository, I suppose, of those public comments, although I also think that if more than one commissioner wants to come, that's great, so long as we notice it appropriately.
Okay. At this point, should we put this in the form of a motion? Or is just general consensus and support work? I guess I should look at the hearing officer. What do you think?
I think it would be helpful to have a motion so we can keep a straight record.
Okay. All right.
So I would move that we hold a public comment hearing that is not a Rule 508 hearing in Broomfield.
I think that's the clarification definitely needs to be there, that it's not a 508 hearing, but it is a public hearing. Okay. All right. All in favor, please signify by saying aye. Aye. Opposed, same sign. Motion carries. I believe what went with that is, I think, was that we worked with Director LaForte to schedule that and what works best with that.
Can I ask a couple clarifying questions?
Yes.
The spacing applications are currently scheduled to be heard at your hearing in Denver on October 30th. I'm assuming you want this public meeting to happen before that,
If that is possible.
and the Rule 508, though I know it's not a 508 hearing, requires 14 days notice. Do we want some reasonable notice of time, place, and date of this hearing?
I think
14 days?
I would suggest that we work with the city of Broomfield to provide notice. I don't think it has to be exactly 14 days since it's not a Rule 508 hearing.
We will cooperate and we could provide the location if you'd like.
That's okay. Doesn't have to be 14 days, but something there, and appreciate you working with us.
I understand what you're saying now. So thank you very much. The city thanks you and I know the citizens are going to thank you. So
All right.
appreciate it.
Thank you again for making the trip down.
Thank you very much. Thanks.
All right. So now we have the, ladies and gentlemen, thank you for stepping back for a moment. This is, I believe, docket number 161000415, 416, and 170500204 and 205. And the hearing officer,
Joe?
is this?
I am. So Joe's show.
We are. Thank you very much. I understand we have, each one has 40 minutes for their presentation.
That's correct.
If it is possible to expedite that, would be helpful. I think as commissioners, we will do our level best to limit our questions to things that are,
Okay, that sounds great.
clarify what's being presented.
And let me just go ahead and start the introduction. We're here on docket number 1610-00415 and 1610-00416, as well as 1705-00204 and 1705-00205. These are applications filed by Highlands Natural Resources Corporation. The protests were filed by Renegade Oil and Gas. The council is present. With the parties please identify themselves? We'll start with the applicant.
Before we start, do either of you have witnesses you plan to call?
Yes.
How about if we share them once, swear all of them in at once?
That would be excellent, thank you.
Motion agrees. Right.
Do you swear to tell the truth? Okay. Thank you.
An example of brevity.
With counsel for Highlands, please identify yourself.
James Perrin, firm of Beatty and Wozniak, representing Highlands Natural Resources.
And Jill Fulcher with Beatty Wozniak, representing Highlands Natural Resources. We also have a few other parties here present today representing Highlands, and if we could take the opportunity to have them introduce themselves as well. Sure.
Scott Anderson from Homo, representing Highlands Resources.
Hey, you're from Homer.
Depending on, you're only going to hear from 2 attorneys for Highlands Natural Resources.
What a relief.
And on behalf of Renegade Oil and Gas.
Joe Pershala, Wilmore Sullivan, Tuli, on behalf of Renegade Oil and Gas Company LLC.
And Jeffrey Storm on behalf of Renegade Oil and Gas Company LLC, also with Wilmore Sullivan, Tuli.
Thank you. Let me just start really quickly. Docket numbers 1610-00415 and 1610-00416 are applications to establish an approximate 1,280-acre drilling and spacing unit in each respective application. The application lines are sections 31 and 32 and sections 33 and 34 in Township 5 South, Range 64 West. Renegade filed a protest to each of the applications, alleging that its farm out agreement precluded Highlands from drilling more than one well in each proposed unit. Alternatively, it proposed that its farm out, the well should be drilled on a 320-acre unit instead. Renegade further argued that if established, the 1,208-acre units would adversely affect its correlative rights. Approximately 6 months later, Highlands filed docket numbers 1705-00204 and 1705-00205, which are requests for additional 15 wells for a total of 16 horizontal wells within each respective unit. Renegade filed a protest on each of those applications with essentially the same arguments in the protest for the spacing application. On August 16, 2017, Renegade withdrew its application without providing any reason for it.
You're not. I'm so sorry to interrupt. I think they withdrew their protest.
I mean, their protest.
I'm so sorry.
Thank you. Conoco had also filed a protest to the increased density applications, which was subsequently withdrawn. The stipulation between Highlands and Conoco was that Highlands agreed to revise its request from the 16 horizontal wells to only 4 horizontal wells. On August 28, 2017, Renegade refiled its protest to the applications, stating that the agreement between Highlands and Conoco resulted in a substantial change because the request was now only 4 wells. And because of that material change, they requested a new application. Highlands objected to this request and objected to the filing of the protest as late and untimely. After hearing the parties at the final pre-hearing conference, the hearing officer allowed the protest and consolidated the matters for hearing. A final pre-hearing order was provided to the commissioners in your portfolio and allocated approximately 40 minutes each to the parties for their arguments. The ultimate issue in these matters is whether the commission should approve the request for 2 approximate 1,280-acre exploratory drilling and spacing units with the 4 wells within each unit over Renegade's protest and its request to create, or its request for 2 320-acre drilling and spacing units for 1 horizontal well in each unit. A hearing officer recommendation was provided in your portfolio under number 46. Now, I did want to clarify, the hearing officer recommendation should also identify that for docket number 1610-00416, the commission should also vacate an approximate 1,280 acre drilling and spacing unit that had been previously established for different lands and established a 1,280 acre unit for 33 and 34. Now, on behalf of Highlands, you may start with your opening statements.
Just one thing.
Sure.
Procedurally, we forgot to ask if there's any conflict of interest amongst any of the commissioners. Hearing none, proceed.
Thank you very much, commissioners. Again, Jill Fulcher with Beatty and Wozniak here today on behalf of Highlands. Mr. Rancy did an excellent job summarizing the applications that are before you today. You basically have 4 applications before you, 2 to establish 2 1,280 acre exploratory units with approval to drill 1 Niobrara well, and then 2 applications to authorize increased density to drill up to 4 horizontal wells in these units for appraisal of the Niobrara formation. And as you also heard, and I want to mention at the outset, staff did issue a hearing officer recommendation in these matters and ultimately recommended that all 4 applications be approved. So we'll speak about that here momentarily, but certainly wanted to draw that to your attention as well. But before I begin outlining the testimony that you'll be hearing from Highlands today, I want to talk about what you're likely not going to hear. And hopefully it will make you very pleased about the remainder of your afternoon. First of all, unlike recent contested hearings, you're not likely going to hear any testimony regarding competing applications or competing development plans. And that's because Highlands is the only operator who has plans for this acreage and is the only operator who's actually brought an application covering these lands to establish units. So no competing applications before you today. Hopefully that's a relief. Second items that you won't likely hear today are a slew of technical testimony or debate on technical issues. You won't hear testimony regarding whether 1 mile laterals or 2 mile laterals are preferred. You won't hear testimony regarding wellbore orientation and what is preferred. And that is because ultimately Renegade and Highlands more or less agree that for these lands, 2 mile wells are preferred with east-west wellbore orientations. In fact, as you likely saw in your in the hearing officer recommendation and in your final pre-hearing order, Renegade is actually stipulated to Highlands geologic and engineering testimony and exhibits. So fortunately, we'll be able to move pretty quickly through that material. So really the only dispute that's before you, or at issue rather between the parties, is whether Highlands should operate this acreage. Unfortunately, that's not a question that you need to consider. That's not a question that you answer anytime you establish units or authorize increased density, because you don't determine operatorship when you approve or deny those applications. So the only question that's really before you today, as Mr. Rancy indicated, is whether Highlands applications to establish 2 1,280 acre units and authorize those 4 appraisal wells will prevent waste and protect relative rights. Very, very simple. And it's something that you do regularly. So we'll turn first to the Act. As you know, there are really 2 chief considerations before you when establishing units and authorizing additional wells, and that's whether those applications will prevent waste and protect relative rights. As you know, there are multiple definitions of waste, and that includes stranding of minerals, drilling unnecessary wells, and inefficient development. As Highlands testimony and evidence will show today, Highlands applications prevent all of these types of wastes. First, Highlands testimony will demonstrate and affirm that they plan to drill these 4 appraisal wells to the Niobrara formation to gather data and then move on to full field regional development. Once they drill these 4 appraisal wells, they'll know exactly how many wells will then be needed for infill development and the appropriate setbacks between those wells. So these 4 wells are indeed necessary. Second, approval of the applications will result in efficient and economic development. You'll receive testimony that the estimated ultimate recovery from these wells will be efficient and will also be economic not only to Highlands, but to its partners. And finally, you'll hear testimony that approving these 4 appraisal wells and establishing these units as 1,280 acre units will minimize and eliminate stranded minerals. And that's because we'll be able to access more of the reservoir and eliminate internal setbacks. As you all know, without the 1,280 acre units in place, the rules call for pretty substantial setbacks, which limits the amount of reservoir that can ultimately be developed by any operator. So the applications prevent waste. The second chief consideration, do they protect relative rights? And the answer to that question is again in the affirmative. First, Highlands testimony will demonstrate that the 4 wells that are will be initially drilled in this acreage will drain about 570 acres. So that is less than the total area that is being proposed for these units at 1,280 acres. That means the correlative rights of adjacent owners are protected because we're not draining their minerals impermissibly. But the correlative rights of owners inside the unit are also protected by way of their inclusion in the unit. By being included in the unit, that means that they have the right to obtain their just and equitable share of production, very simply. So correlative rights are protected. So what you'll see and what we hope you see today is that our case in chief is relatively simple. We'll be moving through that information as quickly as we can for you. And I want to lean a little bit on the staff recommendation, and you also hear testimony supporting staff recommendation today. A couple of items to note in the staff recommendation, and again, what you'll hear today. First, by way of the farm out agreements between Highlands and Renegade and Highlands and ConocoPhillips, Highlands is an owner with the right to drill in these lands. The hearing officer satisfied herself of this fact and made note of it in the hearing officer recommendation. So Highlands has standing to bring this application and has the right to drill in these lands, plain and simple. And you'll hear evidence to that effect today. Second, 1,280 acre units are in keeping with the uniformity of the acreage surrounding this area and will allow for efficient reservoir development by, again, eliminating those internal setbacks I spoke about earlier. And finally, as detailed in the staff recommendation, these applications will prevent waste and protect relative rights, and there really isn't a technical dispute before you today. Again, further illustrated by the fact that Renegade has stipulated to Highlands geologic and engineering testimony. A couple of final points for me before I hand it to Mr. Parrott for a few other remarks. Highlands proposed these units approximately a year ago, actually a little over a year ago. And since that time has really been patiently waiting to get moving, but has ultimately found itself kind of in a holding pattern as a result of, among other things, Renegade's protests. So we would ask that you end that wait here today and accept staff's recommendation for approval, approving all 4 of these applications so that Highlands can get moving in development of this acreage. So Mr. Parrott actually does have a few other opening remarks, and then we'll proceed.
Well, as my co-counsel, I think, very adequately described, Highlands' plans for the application lands, and by the way, I did practice saying that about 6 times today, are very appropriate for this area. They're what we would call kind of a straight shot down the fairway. It's just right in line with all the development that's happening. We do expect to hear a number of points from Renegade today pertaining to issues that are not relevant to the Commission's criteria for establishing joint and spacing units. And we expect that they're going to try to put us in the weeds, confuse and obfuscate issues. And so it's primarily going to be my job to try to get us back onto the fairway. So if you're hearing from me, you're probably going to be hearing me trying to get us back on the fairway. If you're hearing from Ms. Fulcher, you're probably going to be hearing about how these applications are right in line with what the Commission has criteria to establish joint and spacing units. So a few things that we do expect to hear from Renegade. So we expect them to say that the application should just be denied outright, that Highlands can drill a lease line well, or sorry, a lease basis well. And that means that Highlands could pool leases and drill across lease boundaries once the leases are pooled under Rule 318(a), which requires 600-foot lease line setbacks and 1,200-foot interwell setbacks. Well, there are a lot of problems with that approach. First of all, the 1,200-foot interwell setback allows us only 4 wells in a 1,280-acre area. That is a tremendous amount of waste. As you'll hear our witnesses describe, 4 wells is probably only going to recover about 570 acres of resources. So there'd be a lot of waste with
without a unit. Secondly, without wells being drilled close together and proximate in time, our witnesses are going to describe some negative effects such as well batching and waste, and they're going to describe some positive effects that can come from wells being drilled close together and proximate in time, such as zipper fracking. Alternatively, Renegade is proposing that we adopt a unit that we are affectionately referring to as a trench unit. This would be a quarter-mile tall by quarter-mile tall by 2-mile wide joint spacing unit. It essentially is just a one well unit. So it's just long and narrow like a trench in the ground. So we're trying to come up with a way of describing that without saying quarter-mile by 2-mile wide unit every single time. So the side effects of trench units, again, are that wells cannot be drilled close together and proximate in time. It's one well at a time, provided that approval is given by the commission for multiple trench units, which is definitely not a guarantee. We have some of the same problems with no joint and spacing units we have with trench units. And on top of that, we have a tremendous waste of commission resources, because we're going to be back here over and over and over again asking for these little tiny trench units. Another issue that we expect to hear from Renegade is allegations that their correlative rights will be harmed. And per the hearing officer recommendation, Renegade can participate in wells, and in fact, nothing is stopping Renegade from applying for and drilling its own wells. So clearly there's no harm to correlative rights. We're also likely going to hear that the change of the application from 16 wells to 4 wells is a huge defect, and that 4 wells is not enough to develop the application lands, and therefore Highlands plans should just be denied outright. Well, that's a misleading path, because nothing is stopping Renegade from applying for more wells. In fact, Renegade has had a leasehold interest in these lands for almost 30 years, and it has never brought you an increased density application. It can certainly go do that itself. If it has the data, it should do it. Highlands wants to drill some wells, gather some data, come back to you when it's an appropriate time, and ask for the increased density then. A few other things we're probably going to hear: 600-foot setbacks, too big, it's going to cause waste. Same issue. We can reduce setbacks when we have data. Renegade can apply to reduce setbacks. They're probably going to bring up some contractual issues that are simply not relevant to the commission's jurisdiction, such as Highlands is only allowed to drill one well in the application lands. That is absolutely not true. If they believe that there's some sort of contractual issue, they're certainly welcome to deal with that in court. Highlands does not believe there is a contractual problem. And then finally, there's this notion that Renegade is somehow losing the ability to control its own acreage, and that Highlands is stealing that away from Renegade. But again, Renegade has had a lease from the state of Colorado since 1989, almost 30 years. That lease is supposed to benefit schools and taxpayers and public infrastructure. And Renegade has been holding that lease for 30 years. It currently has 1 vertical DJ sand well producing in this entire acreage. So even though it asserts that it wants to control development, it has done nothing concrete for 28 years to realize that. And I'll stop there.
If I may. Yep. So much for opening statements, not closing argument. Without going into a history of spacing and the reason we have spacing, this commission was created to address the ills of rule capture and haphazard development. And to address those issues, this commission was given broad authority to evaluate and establish proposed drilling and spacing units. But it should only be establishing those units when there's a necessary need to prevent waste, avoid the drilling of unnecessary wells, or to protect correlative rights. It's Highlands, as the applicant, that must satisfy that burden of proof. What you just heard was Highlands flipping that burden, saying that it's Renegade's obligation to show that its correlative rights are going to be heard, or that this development is going to cause waste and injure its rights. But that's not the burden. The burden is on Highlands. It needs to show that without this unit, waste will be caused or that its rights will be harmed. It's nothing we've heard goes to either of those issues. And the commission is not required to establish the units here today. You have broad discretion. You can deny this. You can do alternative development patterns. There's nothing that mandates the commission accept Highlands proposals here today. And what you're going to hear is that Highlands saying that there is no issue of waste, that there are no unnecessary wells, or there is no injury to its correlative rights that necessitates these two 1,280 acre units. But rather, the issue that's here before this commission here today is how to balance ownership, contractual, and correlative rights. And as Ms. Fulcher said, this is not about competing spacing units. Renegade is not here to propose an alternative 320 acre unit in and of itself. Renegade would prefer to see this land drilled on a leasehold basis. That was the purpose of the farm out. And it would satisfy Highlands' obligations under his farm out with ConocoPhillips. Quite simply, this is not a necessary unit for all these parties' rights to be respected. And we're here today because this hearing follows more than a year of hard-fought business negotiations between these parties. Negotiations that have never given fruit to Highlands' hopes to obtain from Renegade leasehold in sections 32 and 33, or the right to drill more than one well. That is a critical point. It's about Highlands attempting to use its limited contractual rights to drill a single well in each of 32 and 33, and to apply to the unnecessary 1,280 acre drilling spacing units. These spacing applications do not result in Highlands obtaining any additional rights from Renegade. That's what it wants. It wants to go drill more wells. It wants to get a leasehold interest in 32 and 33, and it's not worked to date. Following these applications, then months later, it filed for increased density to turn up the pressure on Renegade. But Highlands applications, even with these applications, they were never able to negotiate additional rights from Renegade. And Highlands applications now ask the commission to confer upon Highlands rights beyond what it bargained for and to leverage concessions from Renegade. And it's really what amounts to land grab. The evidence is going to show that Highlands has publicly represented that it has the contractual rights to drill up to 24 wells within 3 1,280 acre drilling spacing units. But Highlands owns neither mineral interests nor leasehold interests in the two proposed DSUs. Instead, the only reason, what you're going to hear is that the only reason that Highlands has standing as an applicant is because it has contractual farm out rights with Renegade and ConocoPhillips. You're going to hear that Highlands contracted with Renegade in a farm out to drill just one well in section 32, and just one well in section 33. And upon drilling these wells, Highlands is only going to earn wellbore interests, not leasehold interests that would give it additional rights in those lands. Highlands has a farm out with ConocoPhillips that apparently allows it to drill up to 6 wells, 4 of which are already permitted in lands to the north in sections 15 and 16, and 2 of which they've already drilled. And the 2 wells for which Highlands is seeking to establish these 1,280 acre units will satisfy its obligations with both Renegade and ConocoPhillips. It doesn't need more wells. The evidence is going to show that Highlands has several options under existing spacing orders and contract rights to drill the wells that are called for under both of their agreements. Highlands' technical evidence, which we've stipulated to, shows that these proposed wells will only drain 142 acres. That's they're insufficient alone to develop the entirety of the 1,280 acre unit. But you also hear that within Renegade's compromise of a 320 acre unit, you'd be able to drill more than one well. You'd be able to actually drill up to 3. And in compromise of this, these parties dispute, Renegade has come to the table to offer solutions. And that's this 320 acre units that we're talking about here, what have been deemed these trench units. But what you're also going to hear is that Highlands is saying that Renegade's proposal is a whole bunch of these stacked trench units, one after another across these lands. That's not the proposal. Highlands can drill single wells. The 320 acre unit accommodates those single wells. It protects Highlands' right to drill. It protects Renegade's correlative rights. Now, As you also just heard from Highlands, is that they're going to talk about waste, claims of well bashing, issues of multiple operators. All these claims are red herrings, and a number of them are based on straw man arguments. What Highlands is asking is for this commission to really set bad policy. We don't want the commission to be elevating contractually given right above leasehold rights and mineral owner rights. And that's the slippery slope that Highlands is asking this commission to go down. It's essentially Highlands with one stick out of that proverbial bundle of property rights, trying to leverage that as a club over Renegade and using the commission as a tool to get there. Renegade requests that this commission deny the applications in their entirety, or in the alternative, to establish the compromised 320-acre units, which will protect both Highlands' right to drill, its contract rights, and Renegade's true rights. And it'll also prevent waste. Thank you.
I can't see clouds, but no, that's not it.
All right.
Are the lights on?
Yes.
Thank
you, Mr. Renegade. All right, Mr. Cabas, please introduce yourself to the commissioners and just briefly provide your background with Highlands.
Thank you, commissioners, for your time. My name is Kelly Cabas. I am from Denver, Colorado. Grew up in Colorado. An undergraduate degree in geology from Middlebury College in Vermont. I was a Thomas J. Watson.
Hello, you have been conducting a meeting for a long period of time. If you need to continue, press 1 now. If not, I'll end the meeting.
I was a Thomas J. Watson Fellow in Environmental Energy Economics and Renewable Energy. I have an MBA from Oxford and have worked as an investment banker, oil and gas investment banker with Pt2 Partners in Denver, and joined Highlands Natural Resources as Vice President of Finance, where I work on evaluation of lands, capital budgeting for development of lands, decisions about whether or not to acquire lands.
Thank you very much. All right, so as Mr. Cabas knows, and as the commissioner saw in your final pre-hearing order, Highlands and Renegade actually stipulate to a good portion of the facts pertaining to land. So we're going to quickly go through Mr. Cabas' land exhibits, if we could, to just provide a little overview of the leasehold. So Mr. Cabas, please begin with Exhibit L1. It's your base stamp 74, and explain the leasehold ownership in this unit.
Sure. So L1 shows that the application lands are owned, the leasehold is owned by ConocoPhillips and Renegade. Conoco owns Section 31, Renegade owns 32. Highlands has farm-out agreements with both Conoco and with Renegade. With Renegade, we have the farm-out right to earn a 100% working interest in one well. And in Section 31, we have rights to drill continuously with no limit on the number of wells. It's an unlimited continuous drilling option.
And moving to Exhibit L2, with respect to...
Objection,
He's testifying to an out-of-court statement, for the truth of the matter asserted. And we don't have the Conoco agreement in front of us to verify whether or not that agreement gives Highlands the rights to drill unlimited wells in Section 31.
May we respond? Yes. Mr. Prashala himself implicated the Conoco farm out in his opening statement, and Mr. Cabas, as he stated, is intimately involved in all aspects of land acquisition and management. And as such, he was party to the negotiations that took place between Conoco and Highlands, and therefore it is his direct experience, not hearsay.
I would presume that you could produce this agreement if necessary.
We actually did produce a redacted copy of the agreement for the benefit of Director Rapport and the Attorney General and the hearings manager and the hearings officer at a show cause hearing a few weeks ago. Staff examined that agreement and satisfied themselves as to the contents of the agreement. The contents of the agreement are subject to a highly restrictive confidentiality provision, and we're not at liberty to make that agreement public. So as a matter of evidence, we'd ask the commission to relax the rules of evidence under 519 to the extent they think necessary to protect extremely confidential and trade secret information.
If I may, Chairman, during the final pre-hearing conference, the issue of this exact statement was raised that the Conoco agreement gave Highlands unlimited rights to drill as many wells as it wanted. And my recollection is that the hearing officer who had reviewed that agreement disagreed with that statement and agrees with the interpretation that we put forth in our opening, that it is a 6-well limitation.
I have to object now that counsel is testifying and himself offering hearsay.
So I think I'd like to clarify this since the hearing officer is here. Would you please elaborate on what your understanding is of the agreement?
Sure. I mean, without getting into the details of the agreement, what I can say is that from my review of the agreement and from my discussions with counsel for CONOCO who was here earlier this morning, the agreement gives them the right to drill a certain amount of wells within 3 different proposed 1,280 acre units. It was my understanding that it was not an unlimited number of wells. However, for purposes of these applications, it does give them the right to drill at least the 4 wells that are being requested within these proposed units.
Fair enough. I guess I'm inclined to that, and I guess I would, what's the proper term, sustain your objection?
Thank you.
I'm sorry?
Oh, I know, Mr. Davenport.
Yeah. Go ahead.
All right, can we proceed?
Yes.
All right. Mr. Cameron, let's go ahead and turn to Exhibit L2, and if you could just briefly explain the surface and mineral ownership in these lands.
Sure, the state of Colorado owns 100% of the mineral interest in these lands. The lands that are leased to Renegade, the state has a 1/8 royalty in those lands, and the lands leased to Conoco has a 1/5 royalty interest. So cumulatively, that's a 16.25% average royalty interest for the state. And you'll see later in our engineering testimony that equates to something like $3.5 million of cash for the state of Colorado per well drilled, 2-mile well drilled.
And apologies, but surface ownership again?
Surface ownership 100% from the state as well.
Excellent. And let's move to Exhibit L3. If you could explain the image that this exhibit fits.
So this shows, it's an aerial photo showing the application lands for our western drilling spacing unit. First off, it shows some residential development to the south, so there's that consideration in terms of minimizing traffic, noise, dust, that kind of concern that the local community might have. It also shows our proposed initial assessment drilling plan with Niobrara B and C well drilled as a pair in the north, and the Niobrara B and C well drilled as a pair in the south. And those wells would be drilled in a way that we could understand the pressure response and drainage response of the reservoir, and then determine how to come back and fill in the rest of the reservoir with a full field development plan.
Thank you. And then let's quickly just jump to Exhibit L5. If you could further elaborate on any sort of surface considerations with respect to the topography of these lands.
Sure. So there, as you can see here is a topo map. There is significant topography in the application lands. There's also some water features to the south, some ponds or small streams. In addition, the state lease specifies a pretty strict approach to development of surface locations and a tiered approach on where surface locations should be permitted and developed. And so in combination with that residential development shown earlier, we think there are a number of important surface applications or surface considerations. And our approach is to consolidate and minimize surface disturbance by drilling from one pad in the center. That's only possible if the 1280 is approved, of course. You wouldn't do something like that if it was subject to trench units. So there are a number of environmental and social considerations.
Thank you very much. And then one final thing with respect to the surface, do these lands happen to fall within the area that would be known as the Lowry bombing range? And are there any other considerations there?
Yeah, so this whole area is the Lowry bombing range. It was in World War II used as a bombing test run range. It was a Superfund site. It was remediated by the Army Corps of Engineers, and the federal government gave it to the state of Colorado, which then leased it to Conoco and to Renegade. So what we're proposing is to do full field development on 1280 in an area that was formerly a Superfund site and generate for Colorado $3.5 million in revenue approximately per well.
And let's move to Exhibit L1 from docket ending in, I believe, 416. This is Commissioner's Base Stamp 75. If you could just briefly describe the differences in leasehold and what we would consider the Eastern Drilling Spacing Unit.
Yeah, this is the Eastern Drilling Spacing Unit. It's substantially the same. I think for the purpose of time, we could probably say that all of my previous statements apply here as well. And it's just a mirror image in terms of the leasehold position from Conoco and Renegade.
Thank you very much, Mr. Cadmus. I think in the interest of time, recognizing that the remainder of the exhibits that were submitted in that second docket are similar, we'll go ahead and move through those. And one final comment. Oh, go ahead, Commissioner.
Excuse me, just a point of clarification. I think one thing I want to make sure that it did say that the statement about the ability to drill unlimited wells has not been clarified. So that statement should be part of the record.
Okay, so noted. I think my co-counsel would like to say something here.
Thank you, Commissioner Benton. Mr. Cadmus, is it true that under your contractual relationships, you do have the rights to drill the authorized wells in the application lands?
That is correct.
Thank you.
Thank you for that clarification.
Is that 4 wells or unlimited wells? I heard you guys say wells.
Well, for purposes of what's before you today, what we're asking for is 4 wells, and it's Mr. Cadmus' testimony that we absolutely have the authority to drill those 4. I think that Highlands would disagree fundamentally with Renegade with respect to what the Conoco farm says, but I think for your purposes today, you can satisfy yourself that we can at least drill the wells that we're asking for.
I did just hear from Conoco's attorney, who says they're listening in, and they did confirm that it is not unlimited, that it's 1 well, and then when that well is reducing, it's up to 6 wells, 5 additional, and it's not unlimited. There are specific terms and conditions in that contract that must be met in order to earn the right to drill. So it is not an unlimited right pursuant to Conoco's attorney.
Thank you. Appreciate that clarification.
If I could very quickly ask Mr. Cadmus if exhibits L1 through L1 through L6, I believe, which is base number 74 through 85, were prepared under your direction and control?
They were.
And is the information in these exhibits true and accurate?
Yes.
We would ask for these exhibits to be admitted into the record. And we have no further questions from Mr. Cadmus at this point.
Just a few questions here. Well, one of the few from Mr. Cadmus. Mr. Cadmus, it's true that that Highlands has no mineral ownership rights in the application lands, correct?
We certainly have significant rights in the mineral application lands.
That was my question was, does Highlands have any mineral ownership rights in the application land? Does it own minerals in the application?
We do not own minerals in the lands.
Does Highlands own any leasehold rights presently in the application lands?
Yeah, I think it's misleading to say that we don't have rights very similar to these leasehold rights that would allow us to drill. And we can talk about the number of wells. Our opinion is it's a continuous drilling provision that allows for an unlimited amount of drilling. And Ms. Trancy, certainly respect your input on that, but we do have a strong opinion that it's up to an unlimited number of wells.
The question was, does Highlands presently own leasehold rights in the application lands? No.
No, we do not.
No. Are you under any drilling deadlines to drill the Jupiter or Ulysses wells in the application lands?
Objection, this was not raised on direct testimony. It's outside the scope of cross.
I think it's entirely relevant. It's dealing with why there's a need for the present needs for these applications.
We didn't ask Mr. Cabinets about any specific wells. So I don't understand where this is coming from. These are specific wells that were never used. Correct.
Well,
May I respond?
you may, and I need to have a brief discussion with council.
There was an exhibit that showed where they were planning to drill 4 wells. These wells that I'm referring to are part of the commission's records, and the commission can take administrative notice of them, and entirely relevant to the discussion.
Moment, please.
What base number would that be?
I'm sorry.
Where those wells are shown?
It was L.
Commissioner Jolly, it's base number 78.
I'm going to overrule that objection, and I think it is germane for you to answer the question as to timing on drilling the wells. It's important, you know. I'll elaborate very briefly. There's a farm out agreement in place. Typically, a farm out agreement has some time constraints about when you should proceed. I think it would be fair to answer the question. Thank you, Mr. Chair.
Sure, so under the Conoco agreement, we had to drill the first well by September 1st, which we did. We had to drill the second well within 60 days of that first well, which we did. And then we have a 90-day clock after that second well, which we are in compliance with and intend to comply with.
Are there any timelines to drill the Renegade wells?
Those timelines, I believe, were removed in the Second Amendment to the farm out agreement. So no.
Where were the first wells drilled that you were just referring to?
Those first wells were drilled in sections 15 and 16.
And have those wells been completed?
Those wells have been drilled, cased, and cemented, have not been completed yet.
Is the rig still on location to drill additional wells?
The rig is still on location, and we do expect to complete those wells well within the timeline provided.
Now, in your applications, they don't specifically reference, but my understanding is that you're looking to vacate order number 535612 for sections 35, 34, and 35. That's a 1280. Is that correct?
That's correct.
And that includes section 34, which is you have a farm out over from Conoco.
Correct.
And that existing unit allows for two mile horizontal wells.
Correct.
Is there any regulatory reason or prohibiting Highlands from drilling those wells?
There's no regulatory reason, no.
I don't have any other questions for him.
Thank you.
Maybe just one follow-up redirect for Mr. Cabinets. Mr. Cabinets, is there going to be any sort of, would there be any sort of downside of drilling sections 34 and 35 as is currently spaced, like with respect to, adjacent minerals?
There's definitely a practical limitation. So the opposing counsel asked if there was a regulatory reason. There's not. There's certainly a practical reason, and that is that the resistivity in the reservoir, which is the indicator for the Niobrara Formation, falls off sharply to the east. And so by spacing and drilling under the existing order, it would potentially strand a section to the east, and you would have to drill 1 mile laterals, which would cause drilling of unnecessary wells, cause waste, etc. So not only is that economically harmful, but it is, from an efficiency perspective, harmful as well. And our geologist can certainly provide more color than I can on that. He has extensive mapping of the Niobrara and can show exactly why you would not want to space that way.
So the section to the east would be section 36. Is that the one you're concerned about the stranding?
35, yeah.
Or 30, well, I thought you had 34 and 35 are currently spaced.
35 is less desirable. So we have 33 and 34 under the current application. 35 would be, you start to get more risk there.
Sorry, my mistake. 31, 32, 33, 34. Sorry.
Mr. Kevin, just one final question. Under the Conoco agreement, what happens after you drill the first 6 wells?
We have the.
Objection, hearsay.
No, it's important, I think.
So under Rule 519, the commission has the authority to allow hearsay if people in their ordinary course of business would consider the evidence probative. And I think this is, as Mr. Kelly just stated, certainly probative of all of the issues at stake here. Yes, go ahead.
This is an agreement. It's never been produced in this matter. We've never even had a chance to review it to verify the veracity of the testimony that this gentleman is about to give concerning it. It's an out-of-court statement. There is no ordinary course of business exception for an agreement. It's not a document that he would have prepared in his routine job record keeping. It's not a fair representation of the exception to the hearsay rule.
Mr. Chair, may I ask a question?
Yes, you may.
Mr. Parrott, can you please help me understand why the Conoco agreement is relevant here? Why do I care what the Conoco agreement says in terms of resolving this dispute here?
Well, the Conoco agreement gives Highlands the right to drill wells in sections 31 and 34. Now, the commission all the time establishes units where the applicant has the right to drill in some of the application lands, but no leasehold whatsoever in the rest of the application lands. In fact, the commission did so quite recently, about a year ago in October, and over the objection of another operator, established a 640-acre drilling and spacing unit applied for by Cut Creek, in which another operator owned 100% of the leasehold in part of those lands. And so likewise, we have a situation where the applicant has the right to drill in half of the application lands, and as Mr. Cabinets has testified, it is their interpretation that they have the right to do ongoing, continuous drilling.
Is it possible for all of us to all just agree that the applicant has the right to drill in those lands and leave the other details of the agreement aside?
Absolutely.
That was where I was going to go also.
I'm sorry.
We're save a lot of time.
It occurs to me that there's probably sufficient evidence that Highlands has the opportunity to drill additional wells. I think it's not germane as 1 or 100. It's that you have the opportunity to go drill additional wells. If we could just leave it at that and move on.
Absolutely.
Thank you.
With that, I think we'll thank Mr. Cabinets and ask for Mr. Childs to step forward. All right, Mr. Childs, go ahead and introduce yourself to the commissioners and briefly provide your background with Highlands.
Thank you, Jill. Thank you, commissioners. My name is Whit Childs. I'm a proud alumni of Colorado College. I graduated in 2011 and subsequently moved to Denver. I've worked for several independent oil and gas companies who have had acreage positions throughout the DJ, all the way up into Wyoming, as far south as this. My primary role at each of those companies was to study Wattenberg and the extension areas, the extension areas of Wattenberg and the Niobrara Formation and other formations that have been productive in the field.
Thank you very much. As I said at the outset, Renegade is actually stipulated to Mr. Childs' exhibits and testimony. So with that stipulation, we're going to move very quickly through his geologic slides. And if we could, just ask Mr. Childs to summarize your conclusions of the Niobrara Formation underlying these lands.
I will do that as quickly as I can. This is a cross-section across one of the DSUs. It shows vertical wells within that DSU and just outside of it. What you're looking at is a gamma ray well to the left, a resistivity well to the right. You can see the tops of the Niobrara down to the Fort Hayes. The Niobrara in this area is about 300 feet thick. The pay area, the net pay area, which you can see the resistivity is that green shaded section. That is from the bottom of the Niobrara C to the top of Niobrara B is about 65 feet.
And is it your conclusion that the Niobrara exists under the entirety of the application lands?
Yes.
All right, and were exhibits labeled G1 through G6 in each of our respective applications, Bates 86 through 97, prepared under your direction and control?
Yes.
And is the information in those exhibits true and accurate?
Yes.
All right, I would ask the commission admit those exhibits into the record And recognizing that we've stipulated to this material, I think if you have any questions, Mr. Childs would be happy to answer.
Move on.
Excellent, thank you. One thing.
I just have one question for the witness. Mr. Childs, is the geology in section 34 as good as the geology in section 33?
The geology in section 34, if we look at the cross section through there, it looks like 33 and 34, the Niobrara formation is consistent.
That's the only question I have.
And no redirect, so thank you very much, Mr. Childs.
Thank you.
Now we'll ask our final witness to step forward, Mr. Stephen Miller. All right, Mr. Miller, go ahead and introduce yourself to the commissioners and explain your background with Highlands.
Hi, my name is Stephen Miller. I'm the Vice President of Operations. I have a petroleum engineering degree from Texas A&M University. My work experience is primarily in hydraulic fracture stimulation. I have a very in-depth knowledge of how a hydraulic fracture will affect the reservoir and how the reservoir responds to the hydraulic fractures.
Thank you very much. And again, Renegade did stipulate to Mr. Miller's exhibits and testimony with respect to our case in chief, so we'll just move very quickly through exhibit E1 in particular. Mr. Miller, if you could explain your volumetric calculations with respect to these units.
Yes, this table here is our table of analog wells. We used it to calculate EURs and estimated drainage areas. The estimated drainage area we got for our, we took those estimated drainage areas and normalized them to a 9,500 foot lateral, and that gave us an estimated drainage area of 142 acres with a drainage radius of 325 feet and an EUR of approximately 419,000 barrels per well.
Thank you very much. And based on that estimated drainage area, I believe you said 142 acres for one well. What would that approximately total for the four wells, four appraisal wells that are initially proposed by Highlands?
568 acres.
And is that area less than the total unit size of 1,280 acres?
Yes.
And you mentioned that the drainage radius for a single well would be around 325 feet. Is that less than the setbacks that are requested at 600 feet?
Yes.
So is it your conclusion that approval of the applications will protect relevant rights?
Yes.
And will approval of the applications prevent waste?
Yes.
And finally, is it your conclusion based on your analysis that these wells will be economic and efficient?
Yes.
Well, thank you very much. I guess one final point of order. Were exhibits E1 and E2 prepared under your direction and control?
Yes.
And are they true and accurate?
Yes.
Thank you very much. I move to admit those into the record. That concludes our questions of Mr. Miller. If you have any questions, he's here.
I do, but do you have any questions first?
I do have some questions for him.
Go ahead.
Can I go first?
Go ahead.
Thank you. Mr. Miller, would you agree that the proposed wells will not drain an area larger than the 320 acre unit that Renegade is proposing?
Well, that's a good question. If the proposed wells were drilled on a 320 acre unit, they would not, but then you would have stranded reserves within the rest of the unit, and no other wells could be drilled in that area.
So your answer is yes?
Correct.
Now, Highlands requested 600 foot setbacks, correct?
As far as I'm concerned, yes.
And are you familiar with where the two pending APDs for the Jupiter and Ulysses wells are located?
Yes.
And those are located 946 feet off of the southern unit boundary, correct?
Those are public record, yes.
I don't have any other questions.
So I would ask you to speculate a bit. Given what you've shown here, it would appear that within this 1280 that if these wells are successful and sort of meet your engineering work, subsequent wells are going to have to be drilled. How fast would you follow on with subsequent wells?
Yes, I would agree that subsequent wells would be drilled, but I would have to divert to Kelly Cadmus, our VP of Finance, to kind of discuss the timing involved with those.
How about from an engineering standpoint, what would you want to do?
From an engineering standpoint, I want to develop them as quickly as possible.
And how do you plan on, if you do follow on with the wells, there's always a concern about pressure depletion here, about what you would do to protect these wells. There's some drawings that shows potential loss of frac pressure, the fracs migrating into these wells. What would be your operational plans on that?
Our operational plans are I've got some slides a little bit later on that got this detail and specifics. But our operational plans hinge on prudently developing the acreage, drilling the wells on the north and south boundaries close together. That way we can gather enough data to optimize the fairway drilling per se, to minimize the losses that we would see and the stranded acreage and inefficiencies.
Okay, thank you.
And Commissioner Benton, I would also add that while that concludes our case in chief testimony, we did prepare some rebuttal slides in anticipation of the presentation we're likely going to hear from Renegade. And so you will actually see some additional testimony from Mr. Miller to your question.
Thank you. Hopefully we got some of those answered now, so we don't have to go back over it again.
Excellent point. If I could just ask one final redirect. Mr. Miller, you indicated in your cross-examination answer that one well would not drill outside of the 320-acre trench unit that's being proposed by Renegade, correct?
Correct.
But would the 4 wells that are planned by Highlands drain an area larger than those 320 acres?
They would.
All right, thank you very much.
Mr. Chair, I do have a question. And I'm not sure if Mr. Miller is the right person to answer it. My understanding is that you would hope and would plan to drill more than the 4 wells. In fact, your original application, your density application was for an additional 15 wells, and then you withdrew that pursuant to your stipulation with ConocoPhillips. So as I read the stipulation, you're limited to 4 wells. My question for whichever witness counsel wants to address it to is, how are you going to drill more than 4 wells if you've stipulated with ConocoPhillips that you can only drill 4?
Thank you, Commissioner Boyan. I think we'll ask Mr. Cadmus to answer that question.
Thank you, Commissioner Boyan. So the approach is quite simple. We would drill the 2 pairs of wells. We would observe how they interact, how the reservoir interacts, and then our engineering team would decide what the appropriate spacing would be, and we would reapply for increased density at that time, based on the appropriate infill development plan.
So would you then need another agreement with ConocoPhillips to drill more than the 4 wells?
Not an agreement with ConocoPhillips, but we would need to be back at the commission with a normal increased density application.
But your stipulation says you'll only drill 4.
The stipulation is for the time being, though. It's so that we will appraise the reservoir and then move forward with full field development later.
Commissioner Boyan, I think part of this is a bit of a legal question because it was a legal resolution between counsel for Conoco and counsel for Highlands. And so the stipulation was that Conoco would withdraw its protests in these matters so long as Highlands reduced its present request down to 4 wells. But there was no prohibition for Highlands to come back and ask for additional wells. Does that help?
That's useful. I don't know whether Conoco agrees with that, but I guess we'll find out. I mean, the way I read it was an absolute prohibition. You'll only drill 4 wells.
Do you want to talk about discussions between you and Conoco?
My general impression is that the commission doesn't want to hear a lot about our contractual arrangements with Conoco and Renegade, but if you want to hear, I'm very happy to tell you what I think it's fairly straightforward that we have these rights. But please let us know what you would prefer.
I'm happy with your explanation. We'll see if anyone else shares my concern.
There are no other commissioner questions. That actually concludes Highlands case in chief.
Thank you. Mr. Roush, how much time does Highlands have left?
Highlands has 12 minutes and 41 seconds. And Renegade has a total of 26 minutes and 21 seconds.
Okay, thank you.
JB Condell, Chief Financial Officer and Vice President of Land, Renegade Oil and Gas Company.
Mr. Condell, how many years of land experience do you have?
I've been in charge of land, 100% land for Renegade Oil and Gas for 27 years.
And just turn to first exhibit. Would you please describe exhibit 1?
These are the application lands for 415. Shows Conoco's 100% leasehold ownership of Section 31, Renegade's 100% leasehold ownership of Section 32, the proposed 1,280 acre unit in red, today's application, the well that is pending, as a pending permit from Highlands in the south half of the south half, and also Renegade's proposed compromise 320 acre drilling and spacing unit that would allow that one earning well, Highlands earning well to be drilled.
Let's move to exhibit number 2.
This is, again, a mirror image. The first one, Docket 416. Renegade owns 100% of the leasehold interest in 33, Conoco 100% in 34. The 1,280 acre unit, the proposed pending burning well, and Renegade's compromised 320 acre spacing unit.
If we can look at exhibit number 3.
This is the two side by side, and it illustrates Renegade's leasehold position. Section 32 and Section 33 are adjacent, and I will discuss further when we discuss the agreement with Highlands. The intent that the wells, the one well in each unit that Renegade farmed out to Highlands be drilled as far south as possible. Their evaluation wells. At the beginning of the negotiations a year and a half ago, Highlands didn't even want to drill them. And they were intended to evaluate the resource in this part of the basin, in this part of the Lowry bombing range, and also leave Renegade's leasehold in the north half and the north half south half of both Section 32 and 33 unencumbered by farm out agreements or spacing units.
Mr. Condell, there was testimony earlier about the state leases that Renegade holds. Can you please explain what those leases, when they're actually acquired?
The lease referenced by Highlands that's 30 years old is not in these application lands. That's Section 15 to the north. That was part of the farm out negotiations between Renegade and Highlands. It is the leasehold that Highlands has drilled their two wells on. The year-long negotiation ended up in Renegade actually selling to Highlands the Niobrara rights in Section 15. The two leaseholds, the two leases issued today in Section 32 and 33 were taken by Renegade in 2005, 12 years ago. Renegade had a 5-year primary term. Renegade negotiated with the state of Colorado, which is the state of Colorado's normal course of action, a 1-year extension of the primary term. Within that 1-year extension in Section 33, Renegade re-entered an old plugged and abandoned well, established casing integrity. We acidized the J sand, we fracked the D sand, we then fracked, isolated the Niobrara C bench,
And after that, we isolated and fracked the Niobrara B bench in a vertical well. And we set the well to production. It produced for a year and a half or 2 years before a subcontractor dropped tubing down the well and we lost the well. But we did establish production. We did test the Niobrara C via fracture and the Niobrara B via fracture. Some very interesting results that Mr. Ingeby can talk about further. In section 32, in July of 2011, during that extended 1-year primary term, we drilled from scratch the Bird State 32-8 well, a vertical well. The objective of that well was the D and J sand production, but on the way down, we took a full core of the Niobrara for analysis and future use. I think that's it. Those are the essence. Thank you.
Can I ask, I'm sorry, so if the well in 33 is no longer producing, how are you holding the lease?
There was a second reentry that we shut in royalty payments because we had established production. Annual discussions with the state of Colorado Land Board about our ongoing operations to try. The well was just plugged 2 months ago, I'm sorry. So we were trying to salvage the well. There's also a second reentry that we're trying to reattach the casing. Kind of a lesson in vertical well reentries that maybe you don't want to do, but we ongoing operations and shut-in royalty payments.
So you're in the adventure phase.
Yes. Got it.
Mr. Kondo, has the state ever raised any concerns with Renegade about the validity of your leases?
No.
Would you please describe the nature of your relationship with Highlands?
Well, Renegade is the farmor and Highlands is the farmee. About a year and a half ago, we got a phone call from a gentleman who's not here with Highlands, but Renegade's known for 20 years, and he said, "You got any well sites down in Arapahoe County? We'd like to drill some wells." And we said we might. And that started a negotiation process. Like I said, it began with one well up in section 15, the 30-year-old lease. Evolved to more wells. The interim step was 4 wells on a farm-out basis up in section 15, and these 2 wells down here. Like I said, at first they said, no, that 32 and 33, that's too far south, that's unproven. They did some more homework, we negotiated, and we settled it on 6 wells. Business dealings being what they are, we ended up selling them section 15 to the north and kept these 2 wells, 1 well in section 32 on a farm-out basis, and granting them the right to drill 1 well in section 32 on a farm-out basis and 1 well in section 33, for which they would earn well bore rights, no leasehold, and no further wells in this agreement. Renegade granted no further wells other than these 2.
Mr. Kondo,
We've established that no problem to drill wells on Conoco's land.
Mm-hmm.
But these are horizontal wells that will enter into your lands. Can they drill more wells on you for your agreement?
No.
Mr. Kondo, with respect to Highlands 1280, proposed 1,280 acres, what concerns do you have with those proposals?
Well, many. It was 1,280 acres with 1 well. Can I go back real quick to the previous question about the farm-out? Certainly. Some of the farm-out timing also, Renegade and Highlands executed a farm-out agreement. Highlands said, we're going to go try to get Conoco. Is that okay? That's your decision. But there was a Renegade Highlands farm-out agreement in place. Then there was a Conoco farm-out agreement. In the timeline of all that, we don't know. You've heard what we've heard as far as what the Conoco agreement says. 1 well will not drain 1,280 acres.
as I said, our agreement specifically calls for the one well in each unit to be as close to the south of the section line as possible. The agreement also calls for this spacing application to seek the minimum setbacks feasible. Now, 600 feet is statewide setbacks. Highlands spacing application approved and drilling in 1516 to the north has 300-foot setbacks from the north and south line. And as I said, Renegade did this deal to prove the acreage and keep our 100% leasehold where we can drill 2-mile wells without ConocoPhillips, without Highlands, intact and unencumbered.
Could Highlands drill a well on your leasehold right now without the spacing?
This one well, yes.
Would you describe for me the why you did the 320 acre units in compromise?
Well, we didn't want to because we thought they could just drill them, get Conoco and Renegade and Highlands sign an agreement for one well, put it all together and drill the wells. It seemed, it was a compromise. It seemed, let's not do what we're doing here today. Don't do, we told them before they filed their application a year ago, we're going to protest. Don't do a 1280. And we said, after they filed and after we talked to them, just make it a 320. I mean, it's the same resource that you see throughout Northeast Colorado. It's the Nyberg Formation. One well won't drain it, but it's not smaller than that always. So let's do a 320 and let's move on and let's get the wells drilled.
One last question for you, Mr. Condo. If Highlands was to drill these wells on a leasehold basis, would they be allocated in the same manner as if they were drilled on a 1280 acre basis?
Yes.
And if Highlands wanted to drill additional wells, could they use well bore exceptions for closer density if they didn't have spacing?
Yes.
So they end up in the same place?
Correct.
No further questions.
Mr. Ansey, when you had your discussion on this, was there any discussion about doing wellbore spacing units here?
Well, we did meet with, we did have
She finally thought ahead, Enrique.
Jane Stanzik, our permitting manager, was present during our final pre-hearing conference, and we did have an opportunity to speak with her afterwards. And wellbore spacing units are pursuant to our statute, our rules rather. Wellbore spacing units are not really allowed outside of the GY area, so it's not something that we would approve, especially this far south.
Thank you for that clarification.
One housekeeping matter, may I, Mr. Condo, were exhibits 1 through 3 prepared under your?
Yes, they were. Yes.
We moved to admit exhibits 1 through 3.
No objection. Okay, what's next?
May I ask a cross-examination question?
Certainly.
Mr. Condell, do you recall situations where the commission has established drilling spacing units in places where Renegade owns leasehold over Renegade's objections?
Yes.
Thank you. No further questions.
Oh, no, that was a wellbore spacing.
Well, okay, do you recall docket 1303 SP 36?
Yes,
that was heard by this commission in September.
South 64.
That was sections 27 and 20.
Yes, the answer to the question is yes.
Okay. No more questions.
May I ask a question, Jim?
Certainly.
I'm sorry, is it Mr. Connor or Mr. Connell?
Condill.
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 So Mr. Condell, the way, one of the impressions that I got based on your direct examination of your counsel was that at the most basic level, it seems as though Renegade's concern is that if the spacing units are granted, either Highlands will violate the the existing farm out agreement, or it will in the future violate the farm out agreement. Is that accurate?
No, the farm outing agreement goes away once they drill these wells. The concern.
Excuse me. So, but once they get the spacing order?
The concern to me is surface use, to be honest with you. Among other things. It pairs our leasehold with Conoco's leasehold. Okay, now, Highland says they own Conoco stuff via their farm. I don't know if that's true. Renegade and Conoco have a history. Conoco drills very, very expensive wells. Renegade would like to remain the 100% owner of 2 mile wells and not be partnered with Conoco. Now, I understand people are going to argue this spacing doesn't partner you well. Okay, but it does. Our concern is we granted them the right to drill 1 well. They asked for 1280 and said, don't do it. It marries those 2 sections 50-50 as opposed to Renegade's leasehold ownership 32 and 33, 100%.
Are you concerned that you granted them the right to drill 1 well and they will drill more than 1 well?
I'm not concerned they're going to drill more than 1 well. I mean, with a 1280, then they can come in and say that we're going to pool it and we'll be at 50% working interest on it, which is fine. But now's the time to avoid that eventuality.
So and now you're opposing the spacing order in part because you're concerned that the spacing order opens the door for other things that you object to. It's not necessarily that the spacing order is a problem, but that there's things that the spacing order may lead to.
Correct. 1280 is fine. I mean, it's fine in theory, right? There's nothing wrong with 1280, but this has specific fact pattern that we worked very hard and negotiated very hard to avoid having this happen, especially if, for whatever reason, Highlands were to lose their rights under the farm out agreement, they stop drilling. Okay, that happens. Now we got Conoco. And Conoco proposes a well where Renegade or Highlands can drill it for 6 or 7 million, and Conoco's going to spend 10 or 11. So what does that do for whether we drill or not, or whether now our leasehold rights and our oil and gas is subject to a $10 million AFE versus a $6 million AFE.
I have no further questions.
Mr. Chair, can I follow that up? Thank you for those questions because they help clarify some things for me, or at least some aspects of this that are bothering me. I don't understand why there would be single well farm outs, wellbore farm outs. Those are highly unusual. And you don't necessarily have to answer this. And I can ask Highlands as well. But normally with a farm out, you contemplate a test of some sort and then some additional learning if the test validates your premise. Here, you've got provision for 2 tests and then nothing. So what was the expectation of Highlands? And I'll let Highlands answer this as well, but it seems to me reasonable to assume that they assumed that they could drill other wells by doing exactly what they've just done, which is to file for this DSU, the 2 DSUs, pool the Conoco and Renegade acreage and drill their laterals. There's no other way for them to benefit from these single well farm outs, unless I'm missing something. So I keep going back to, it seems to me this is a contractual dispute between 2 parties that involves a lot of extraneous issues that we're not privy to. We have no jurisdiction over, we're getting pulled into. So I'm trying to understand how we're sitting here today. It's sort of a question, or maybe it's a rhetorical question.
Sure. The owner of Renegade would like to answer if that's, I mean, as far as business matters goes, this is Renegade, so.
That's fine. We swore him in. He certainly can get up here and speak. would ask again if you could state your name, please.
Okay, my name is Ed Ingby, or Edward Ingby. I'm owner of Renegade Oil and Gas the last 33 years. Petroleum engineering degree, University of Wyoming. The concept here was the acreage to the north was much more coveted. They wanted that acreage. There was 4 wells to be drilled up there. We wanted to prove this. We're 5 miles away from established production here. So we wanted some proving wells on the south side of the acreage. In addition to 33 and 32, Renegade owns 28, 29, 30, 25, and 24 in the adjacent townships. So I was trying to come up with some proving wells down there. And I said, okay, if you want the 15, 16, the 4 wells up there, you got to take these and drill these also. That was the concept, basically, to prove up the acreage.
But apparently there was nothing in your agreement that restricted them from filing this for these 2 spacing units, or else you'd be in court.
The only thing that was within the spacing part of the agreement, first of all, we didn't think they needed to space this to get them drilled, they really don't. But is that if they did space it, that they would obtain the minimum setback possible. And the requirement in the agreement was those wells would be drilled as far south as possible. And they did obtain 300-foot setbacks in 15, 16, so our expectation was somewhat that they would obtain 300-foot setbacks with regard to these application lands, and then drill a well maybe 30 feet off of that or something of that nature.
Commissioner Boyden, in the spirit of full disclosure, Highlands CEO and president is here today. He hasn't been sworn in as a witness, but if you'd like his perspective on your question as well, we'd be happy to have him sworn in and answer your question.
It's up to you. I'm just trying to figure this out.
I mean, if you feel like you've gotten a full enough answer from...
No, that was very helpful. You may or may not agree with it.
That's kind of a follow-up to, so you have 32 and 33, and Conoco bookends you there. In your discussions with them, with Highlands, did you anticipate they were bringing?
They had always indicated that they would love to try to get Conoco brought on board and possibly seek a 2-mile lateral through there, and we did not object to that.
Okay.
We said good luck getting a farm up with Conoco, and that it's going to be full of all sorts of stuff that you're probably not going to like, and the terms are nowhere near as good, so now we're burdened by a well potentially where they're, we've got an 87.5% lease. They've got all sorts of back ends and overrides and higher royalty to begin with. So now our well, actually economics is lesser than would it be as if we drill a well in 32 or 33 miles on its own, our own 2 mile. Our economics are completely different than a joint Conoco and Renegade economics.
That's a good quick question. I think I may have missed it. Did you drill vertical wells in 32 and 33?
Correct. We drilled 1 well in 32. That was before the leasing frenzy happened out there. We obtained that entire core of Chesapeake, who was examining our acreage for possible deals also. We washed down 2 wells in section 33, one of which we completed both in the Niobrara B and the Niobrara C bench independently. Learned all sorts of information about that. Then we drilled a well in 28 to the north, also there, and in addition to having an additional production well in 28, we've also got a well in 29 production wells. So we're very familiar with it operating out here for quite some time. We're familiar with geology, and once the oil price crashes, the area wasn't a lot busier than it is now, and now it's starting to ramp up, and people are recognizing that this stuff is as good as Alcohol County.
Thank you.
Any other questions for Mr. Kondo?
Mr. Kondo can come back, I think. Do we have any more questions for Mr. Kondo?
We have no more questions for Mr. Kondo.
Okay. No more cross-examination. No more cross-examination. Okay. Mr. Ramsey, what's next?
I believe they have your engineering.
Okay. Mr. Roush, how much time check, please?
We have 12 minutes and 5 seconds for Highlands and 15 minutes, 33 seconds for Renegade.
Okay, thank you.
Mr. Andy, would Renegade's compromised 320 acre units allow for uniform development of the surrounding lands?
Yes, I believe so, especially if the minimum setbacks were sought.
And would the compromised 320 acre unit, would that protect Highlands' rights, its contract rights?
With regard to Renegade, yes.
No further questions. Good.
Yes, Mr. Envy, do you recall discussing your farm out agreement with the commissioners a few minutes ago?
Yes.
Doesn't the farm out agreement call for the 2 wells to be drilled? One from the southeast of section 32 into the west half of section 31, if possible, if Highlands could get a farm out from Conoco?
Yes, I mentioned that. They're needed to be drilled by October 1st.
And mirror situation in sections 33 and 34?
Same thing, they got 19 days.
So it's actually written into your agreement that your wells would be drilled across both Renegade and Conoco
It
lands?
anticipated a potential
Is that-
Conoco farm out.
Yes, okay, thank you, no more questions.
No redirect.
Thank you.
No more witnesses for Renegade.
So at this time, if there's any rebuttal testimony on behalf of Highlands.
Yes, we will have a rebuttal testimony. Can you give us just 1 minute to kind of get set up? Great, Officer Darren, I would note that your case management order calls for your recommendation at this point. If you would, I don't know.
It says it's requested by the.
It's requested by the-
Commission, has to request specifically request us now, now.
You got me there.
And that's our general practice, but here was also a hearing officer recommendation was provided. Let me start all over. Our final pre-hearing order does specifically indicate if requested by the commission, there would be a presentation of staff analysis. We do have Stuart Ellsworth prepared to answer any additional questions. I did prepare a hearing officer recommendation identifying that the staff's.
Hello, you have been conducting a meeting for a long period of time. If you need to continue meeting, press 1 now.
That staff's, that the hearing officer and staff's recommendation is to approve these 2 approximate exploratory drilling and spacing units. So if there are any additional questions, I'm capable of answering them at this time.
I think Stuart has left the building.
That's okay, I can do it.
Thought you might be able to. If it's the pleasure of the rest of the commissioners, stick with the sequence here and go ahead and hear the staff analysis. Busted. Okay, so briefly, if you'd like to do that, and then we'll go on to the rebuttals.
Thank you. So as indicated in the hearing officer recommendation, our recommendation is to approve these exploratory units. Part of our, in our discussions internally, we did consider some of the arguments made by Renegade. However, as the commissioners are aware, oftentimes in establishing a unit, even if there is no farm out agreement, the commissioners have, or the commission has established unit over the objection of a party who owns essentially a large area within the proposed unit. We don't see this as any different in this particular situation. In this case, we have a party that's objecting based on their acreage to the proposed unit. However, the plan that's being proposed by Highlands, we believe is preferable, or is, for lack of a better term, superior to the proposal that Renegade presented to us, both in their protest as well as even presented today. Our concern as well is in the proposal by Highlands, we would have minimal surface disturbances. We would have the opportunity to include infill wells in a way that's because of the, it would be one large drilling and spacing unit. We wouldn't have to be concerned with additional unit boundary setbacks, which we believe would result in reserves left in the ground. And so for all of those reasons, it was our position internally that notwithstanding Renegade's objection and Renegade's farm out agreement, that it would be more efficient and more economic to establish a unit in that as a 1,280 acre exploratory unit.
I have a couple of questions of this. All right. I think they mentioned earlier that there's in their plan that it's a 600-foot setback is what's planned here.
So actually, what was requested in the application was 600-foot setbacks along the northern and southern boundaries, and in 1610-00415, there were east and west boundaries of 100-foot setbacks. And in 1610-00416, there was 600 foot on the western boundary and 100-foot setbacks on the eastern boundary. It's reversed. So it's 100-foot setbacks on the western boundary and 600-foot setbacks on the eastern boundary. So essentially, where their interests are meet, it would be 100-foot setbacks and 600-foot setbacks.
On the other ends, and so that sort of where they come together, they
right, exactly. And I believe it's the tail end of 31 and 32 would also have the two tail ends of 31 and 32 would have 100-foot setbacks, and where 32 and 33 meet would have 100-foot setbacks, but the other end would have 600-foot setbacks.
I understand in the other one that they have 300-foot setbacks. Is that correct? The one up in section 15?
In section 15, I believe they do have 300-foot setbacks, it might be all around.
Is it possible in the event that we go forward with this, that they could reduce that down to a 300-foot setback in subsequent development lots?
Absolutely. We have requests all the time where parties come in and request reduced setbacks, even after wells have been drilled, to include infill wells towards the ends of the units, the established units.
And this is more of a difficult question for me, and I apologize for my ignorance. Has there been a case where, I know we've never done one of these trench units, so to speak, but if those wells ended up being drilled and they wanted to do subsequent development, could you dissolve those units and expand that into a larger dwelling space?
So that was a discussion we did have internally. Now, these trench units Highlands is discussing, they're really the equivalent of wellbore spacing units. That's essentially what it sounds like they're proposing. So we don't have overlapping units outside of the GUI area. It's not something that is allowed really by our rules. So we would have, once those wells are drilled, we would have no choice but to create an overlapping unit, which is not something I know that permitting is in favor of at all. And there would be, because the unit is already established, if the well is already drilled, we wouldn't be able to vacate that unit.
It would be an overlapping unit.
It would be an overlapping unit.
Still the issue of additional surface locations.
Exactly.
Okay.
Well, unfortunately, with the proposal Renegade has given us, the proposal is really, we want a 320 acre unit. That's what they would want. We don't have extensive kind of discussions with them about what it would look like or what their additional plans would be. So what we have is what's been presented in our pre-hearing conferences, and based on what's been presented, especially by Highlands, it looks like there would be additional surface disturbances
in the event that the trench unit.
that there is a trench unit to that.
Okay, thank you. Commissioner, you look like you're going to ask your questions. Okay, all right. Yes, sir.
I hate to belabor this, but so under the farm out agreement that Highlands has with Renegade, if they create a 1,280 acre unit, what is the impact on the acreage, the north, let's just say the north half of the 1280 that Renegade still has, if the well's drilled down in the far south. I mean, it sounded to me like you've got a one well farm-out agreement with Highlands to earn an interest in the wellbore. So is that an interest in that one well covers the entire 1280, takes covers all of your acreage in that section?
Well, that's one of the reasons why we would not like to use it at all. And in the alternative, in the spirit of compromise, we said the 320, how about that? You know, the best, out of that scenario, we're preserving basically a 962-mile unit that Renegade could drill at 100% of density that I wanted to drill. With the acres to the north, we could also do our lease lines to the north, our setbacks to the north in the development pattern. We could locate our surface paths to maybe potentially develop not only 32 and 33, but also 28 and 28 and 29 up there, and optimize facilities that way. Never have we ever approved, envisioned 320 acre units all over the countryside. And that's
is it, assuming that you got your wish and there was some 320 acre spacing unit, would Renegade propose to develop the north half of these areas?
We've been talking to many parties that are very anxious to do this.
Well, I guess, and I'm just trying to understand, I mean, I can certainly understand that if Highland is successful and they drill one well and they somehow earn an interest in all of your acreage in this section, kind of takes the wind out of your sails for your own development.
But the agreement very specifically says they do not earn any acreage. They earn the right to produce that well or not for only.
So who would drill the other wells?
Well, either they would have to propose a well under rights they have a Conoco agreement, and we would have to evaluate them as a partner pooling interest, or we could propose one on them, and they would have to evaluate it, or Conoco would have to evaluate it. At this point, I don't think it would be Highlands, it would be actually Conoco.
Or the parties could enter into a subsequent agreement and resolve all your differences and agree on how you're going to develop this acreage together, which would be a nice resolution.
In the spirit of compromise, that's what we did, but we didn't really get anything out of Highlands except what can we do to obtain more of your acreage.
Well, and honestly, when we were talking earlier, I mean, I could see Highlands incentive here is they don't say any rights to drill anywhere. Whatever they can get, gets their foot in the door.
Well, to be crude, I mean, they're bootstrapping their way into the sections through their two farm out agreements, and then they'll just they'll either pool you or you'll join whatever wells they want to drill. I mean, that's the game, but to me, that's what the rules contemplate. Unless you've got some contractual agreement to the contrary. So, two sophisticated parties, I just don't know why this is our issue, frankly. I am concerned about this 4 well limitation with Conoco, but ultimately, if you don't drill any more wells, then they can drill wells. I mean, they could turn it on you guys. They can propose wells.
Density pattern that we prefer still require us to come back and reapply for several different things, setbacks, densities, all sorts of things. And if they drill a well in there, at least the southern boundary well as contemplated right now, it could prevent or could cause waste on the southern boundary, because I don't know if another well could get in there with 300-foot drainage from either side of each side of the well, or it could cut off or could strain resources there on all sections.
Mr. Albert.
I would just like to express that I'm a little bit concerned that I think we may be veering into deliberative kind of statements, and I do want to note that the record is still open. So I wonder if we can wrap up that issue.
Yep. Agreed. I don't think we're getting there, but we could. So I think it's okay for you to ask those questions.
One second. So that was my staff analysis.
Thank you for that.
At this time, Highlands have the opportunity to present its rebuttal case.
Recognizing you guys are all trying to get to an important meeting, and see the Broncos game, of course. We're only going to present a few questions, about 5 minutes, if you'll indulge us.
Sure.
So, Mr. Cavanaugh, first of all, does the Renegade farm out in any way prohibit drilling more than one well anywhere in the application lands?
No, it does not, and there was explicitly deletion of any limitation in the second amendment to the farm out.
Okay. Turning to your exhibits L7, L8, and L9, if you could spend about just 2 minutes really capturing the impacts to surface and long-range planning from trench units, please.
Sure, I'll try to go quickly. Essentially here on the first exhibit, on the left you have the impacts to surface of a 1280. It is essentially the most efficient approach. You have a centralized pad from which our proposed 4 wells can be drilled, and then hopefully our goal is to drill additional wells. And so it maximizes your efficiency, it concentrates the impacts, minimizes environmental disturbance, roads, traffic, pads, traffic accidents, all that stuff. On the right, it shows the potential outcome of trench units. If you were to set this precedent, at the very least, there's a second pad, more probably because we have additional rights under Conoco, we will be proposing additional wells, which will be requiring additional trench units, and you would have a multiplicity of surface locations, which multiplies surface impacts. The move-in rig-up process is the most impactful portion of drilling on the environment, and so it's more rigs, more frac crews, more trucks, all of that. And our proposal, in my introduction, I give you an overview that part of my background is environmental impacts of energy. We do take this seriously. This is a benefit of our proposal, is that we're minimizing the environmental impacts significantly with our plan. On the next slide, we're talking about why, and comparing and contrasting why the current 1280 facilitates development. Again, there's a big benefit to the state here, $3.5 million per well. We're trying to approach this rapidly, efficiently, and aggressively, and without proper guidance from the COGCC and approval of 1280, it really hampers our ability to develop the lands, and for anyone to develop the lands, frankly. And then the final slide of my rebuttal is a closer look at roads and flow lines specifically. Similar to the first slide, but really looking at the impacts on, again, flow lines, which are very sensitive right now, roads, which are also a big disturbance to the environment and the communities. Trench units could potentially multiply and increase the complexity of all of these surface facilities and all of the associated infrastructure, which our plan would consolidate and minimize and concentrate. And so for that reason, we think that our approach is the best from an environmental perspective, social, community perspective, and certainly from an economic and development perspective.
And Mr. Cavanaugh, you prepared these exhibits and they're true and accurate?
Yes, sir.
I move exhibits L7, L8, and L9 are committed to the record. No more questions for the witness.
No objection. I just have a few questions for us. The commissioners have questions.
I'll let you go first. You may ask the question I have.
Mr. Cavanaugh, I think you heard testimony earlier from Mr. Ingby that isn't it true that Renegade has never proposed stacked 320-acre units? Isn't that right?
To my knowledge, Renegade has never proposed anything in the application plan to do with horizontal development.
If we look at exhibit L8, so I looked through this, and in the column to the right, you have a statement that denying the DSUs would create significant impediment to investment. Can you explain that?
I certainly can. If you go down a path where there is uncertainty with regard to regulatory direction or the approval of drilling spacing units, if they're going to be irregularly sized or shaped, investors are going to have a really significant question about how is this going to be developed, when will it be developed, what's the density that could be developed, who will operate. It just opens up a huge amount of risk for the investor, ability to have insight or planning on basically capital spending and the resulting economics of that capital spending. So without 1280, the economics of this land, in my opinion, are reduced for all parties.
So approval of the spacing units would encourage investment in Highlands, correct?
It would improve investment in the lands.
And would approval of additional locations encourage other investment in Highlands as well?
Let me be really specific. Regardless of who's developing, a 1280 enhances the value of these lands.
But the reason that Highlands wants these spacing units is so that it can encourage investment in the Highlands, correct?
We want to develop these lands in the best way possible for the state of Colorado and for Highlands. We think our interests are very aligned on that. And yes, this would facilitate those goals.
Now, to drill additional wells in these lands, Highlands would have to pool the lands to get that right to drill into sections 32 and 33, correct?
I'm just gonna object, that's a legal question.
I believe it was represented in, first of all, it's land testimony, and second, it was represented in Highlands briefing that they would pool Renegade's interest to be able to drill into their lands. I think he can answer that question.
That was a legal document that was written by myself. And it actually didn't state that Highlands would pool Renegade. It said that one option would be pooling either voluntary or compulsory of the interest. Please.
Advice of counsel, I'm going to overrule the objection.
Thank you, Mr. Chair.
So the question is, would you have to pool Renegade's interest to be able to drill the remainder of sections 32 and 33?
I believe we would, but I do think it's a legal question. I'm not a lawyer. I don't know what other options might be available.
You have experience in land, correct? You're testifying as a land witness?
We would have that option to pool into six.
Would that be voluntary pooling?
If Renegade chooses to participate?
But if it chooses not, you force pool.
That's another option, yes.
So you'd need an order from the commission to be able to drill any additional wells into Renegade's leasehold, correct?
Okay, we've just had him answer the question. Do we need to keep
No, there's no need to keep beating this to death here.
No further questions from Mr. Campbell.
Okay, no redirect.
So I have a brief couple of questions. I think one may be for the hearing officer. And hopefully I'm not going to stray into the area of deliberation. If we deny the application, that doesn't necessarily mean we're approving the trench unit, is that correct?
No, there's no current proposal by Renegade for, actually, they've got a file an application for those.
Thank you. And if we deny the application, then it does potentially cause an issue for you because of your drilling clauses with Conoco for the farm out agreement. As far as timing, is that correct or not?
Well, we have the ability to drill in the north. There's a separate drilling and spacing unit that's already been approved. It's the one that we're working on. So our ability to continue drilling up there wouldn't be affected, but our ability to drill down here would be, yes.
And does that agreement potentially expire? I'm just trying to understand sort of what's your time frame with your farm out with Conoco for this area, not in section 50.
So back to the point of unlimited drilling, once we drill our 6th well, we have 180 days to drill the 7th well, and so forth. And so, assuming we would continue to drill, then we would be able to drill fully in the north, and then once we fully develop the north, then if we didn't have the ability to drill down here, that would be where we run into an issue.
Okay, I think I have an answer there, so thank you.
I have just one other question. Highlands has no other pending BPDs in these lands other than the 2 wells in the very south half, correct?
That's correct.
I think next is, so we have rebuttal by the applicant, so is it rebuttal by the protestant?
Yes.
Mr. Chair, I'm sorry, we have one more rebuttal witness.
Oh, I apologize.
Again, we'll go through the testimony very quickly if you'll indulge us.
Certainly.
Thank you.
How much time do they have?
7 minutes and 45 seconds for Highlands and 11 minutes, 16 seconds for Renegade.
Okay, thank you.
Mr. Cabinet, keep in mind you've got about 2 minutes here. Could you just explain to us if you can't plan development that's close and proximate, what are going to be some of the negative effects?
I'd just like to state my name is Stephen Miller, I'm sorry. Could you repeat the question, please?
Can you just describe the negative effects of trench units and the positive effects of a regional development plan?
Yes, so, trench units would have the effect of staggering development in this area. You would get you would not have, with the regional development plan, you could concurrently drill and develop these wells all at the same time. So we have a phenomenon we call frac batching. It's where you have a parent well that would be drilled in the area, it'd be fracked, it would be completed, it'd be produced. In the image, you can see the parent well, the orange ovals represent pressure depletions after being produced through the fractures. So when you come in and infill drill, you drill what we call the child well. And this is a phenomenon that's been observed in Wattenberg, it's been observed up in the Docket, it's been observed in the Eagle Ford. And when you frack this child well, the pressure and energy from those fractures seeks out that lower pressure regime surrounding your parent well. And those fractures tend to grow asymmetrically and migrate towards the lower pressure regime. And in some cases, you actually have infiltration of the frac fluid into the wellbore and physical damage of the wellbore itself. This could lead to lost reserves and to inefficiencies. If we could jump to E5, this is a breakdown of how best to zipper frac. What this would allow would be to drill and complete all the wells at the same time. And the concept of zipper fracking is you fracture stage 1 in each well, then stage 2 in each well, and stage 3. And this allows you to control the pressure regimes down the wellbore and minimize any adverse effects when you're completing them at the same time as well. This slide here is wells that have been properly zipper fracked and they've been brought on production. And when they're brought on production, they start drawing down the reservoir, and when they enter into communication, this gives you a lot of information about the reservoir itself and the flow capacity, and this allows you to high grade your completion efforts and determine your optimal well spacing, which is what we're intending for our fairway.
And your final activity 6.
Yeah, so this is a 2-scale drawing of the drainage area surrounding each wellbore. And as you can see, if trench units were established and the spacing was upheld for each trench unit, you would end up with stranded acreage between each well.
And this is approximately the case if no unit is established and you have to drill wells 1,200 feet apart on a 318 away, correct?
That is correct as well.
No more questions.
Mr. Miller, just looking at Exhibit 6, again, Renegade has never proposed stacked 328 units, is that right?
As far as I'm concerned, I don't think Renegade's proposed anything.
And are you familiar with the rule 318(a) and that there are wellbore location exceptions available?
I am not.
And there's only one pending APD in each of these proposed 1280s currently, correct?
Well, that's a bit misleading because there's always room to file more APDs.
But currently pending, Highlands has only filed for 2 APDs, correct? 1 well in each unit.
That would be correct.
And are you familiar with the permitting process?
Intimately.
And there's a significant amount of time between the time you file for an APD and the time it's granted, correct?
As far as I remember, there's a public comment period, and then you have to, especially in this area, there's a fairly lengthy process involved with the County of Arapahoe for approval.
And there's no other APDs in the pipeline, correct?
None that have been posted to the COGCC website as of yesterday.
And isn't it true that Highlands has an October 1st deadline to drill these pending APDs in these units, correct?
That would be a legal question best answered by Code Cabinet.
I don't need an answer to the question. I'll withdraw the question.
Consider the question reinstated. I'd like to hear the answer, please.
The farm out with Renegade did specify an October start for wells in the south, but those were explicitly just in the, they were part of the heading that was excluded from the legal text of the body of the agreement. There is no explicit deadline to begin drilling in the winds. and they're subject to the other ongoing portions of the agreement.
Thank you. I did have a different question in it, but you have something else?
No, I don't.
Okay. Your agreement with Conoco, farm out agreement you have with Conoco, if you, wherever you drill, then do you earn a mineral interest? That may not be the right term, you earn a mineral interest in those sections?
We earn wellbore interests in all of the wells that we drill, but non-mineral interests, no.
Thank you.
No further questions.
We don't have any redirecting, we're pulling out our witnesses.
Thank you, Commissioner. So I think we're up to closing statements by the applicant and then by the protestant. All right.
Highlands has 4 minutes, 24 seconds. Renegade has 9 minutes, 10 seconds.
All right, thank you very much. I'll keep this brief. First of all, thank you for your time this afternoon. When Mr. Parrott came to me with the analogy of the fairway, I thought, well, thank goodness I play golf once a year, because I know that you want to ideally be on the fairway and not in the weeds. If I'm in the weeds or in the rough, I've done something wrong. So I'm going to try to keep my comments today, again, to this fairway analogy. We really believe that the issue before you is simple, and I think we've seen that in some of your comments and questions here so far. And the question is, will these 4 units, or approval of these units, prevent waste and protect relative rights? They're the same questions you routinely ask yourself for a slew of matters that are usually before you on the consent agenda. We don't believe that this is any different. And we believe that you saw evidence before you today that the answer to those 2 questions is in the affirmative. First, you heard testimony demonstrating that the size of the units will allow Highlands to uniformly develop the acreage while minimizing surface disturbances. You've also heard evidence and testimony that the wells will efficiently and economically drain the resource, and that Highlands will be able to first appraise the acreage through the 4 wells, and then come back for additional infill development, or any party, for that matter, could come back and ask for increased density. And finally, approval of the units will eliminate those internal setbacks that trigger stranded acreage. So we're preventing waste on all those counts. And secondly, correlative rights are easily protected here. First of all, the acreage that's being drained by these 4 wells, as demonstrated through our testimony, will be about 570 acres. That is smaller than the total area that's being applied for, as 1280. And so adjacent correlative rights are protected. We're not impermissibly draining beyond unit boundaries. And correlative rights of owners inside the unit are protected because they'll be able to obtain their just and equitable share. And again, nothing is preventing requests for reduced setbacks at a later time or infill development. So we would ask that you just strictly apply those considerations like you did this morning to applications on the consent agenda to the applications before you today, and approve these applications consistent with staff's recommendation. I think Mr. Parrott might have a couple more items to summarize.
Actually, I don't have anything right at the moment. I'm going to reserve the rest of our time for a rebuttal closing statement.
Okay, thank you. Statement.
Thank you. What we're seeing today is an unprecedented attempt by a farming to enlarge its rights beyond what it's bargained for. It's got a toehold in these lands, and it's trying to use that as a boot to Renegade's throat, trying to force concessions that never bargained for in contract either with Renegade or with Conoco. They're asking the commission to fill the gap in their poor contracting decisions. They're using the commission as a tool. Earlier, there was a question whether or not, if the commission was to deny this application or to establish the compromise 320, whether or not this commission could enlarge the unit, and it certainly can. The spacing statute expressly contemplates that initially a unit is supposed to be with 1 well, and then after that well is drilled, you come back and you ask for increased density. I know you don't want to hear it, but that's the exact language of the statute, and it will give Highlands the opportunity to come back and drill if it does drill with one well. Highlands, as the applicant, has the burden of proof here, and the burden of proof is to demonstrate that there will be waste without this unit, that there will be unnecessary wells without these 1280 acre units, or that its correlative rights will be harmed without the 1280 acre unit. They've not demonstrated that. In fact, their contract rights, which is all they have, will be protected without a unit. They can drill on a leasehold basis, both in Conoco's acreage and in Renegade's acreage. They're 1 well that they have the right to drill, or under Renegade's compromise 320 acre unit. The facts that are what we know is that Highlands can drill a number of wells in lands to meet its contract obligations. It could drill wells in subject to the existing order 535612, which covers sections 34 and 35. If there's geologic reasons why it doesn't like it, well, it contracted to into the farm out with Conoco. Now it's trying to change and repair its poor contracting decisions. It can drill 4 wells in sections 15 and 16, plus the 2 in the proposed units. That's 6 wells. It meets the Conoco obligations. It meets its obligations with Renegade. We don't know, but it could drill 1 mile wells in 34 and 31, meet its obligations with Conoco. It could drill 2 mile wells in the south half of sections 32 and 33. It could across the Renegade acreage. Under one or more of these scenarios, Highlands has the present ability to drill its wells to meet its contractual commitments with both Renegade and Conoco without these units. Yet Highlands is choosing to seek to establish unnecessary 1,280 acre units in partner 2 entities that have made no agreement to be partnered. If Highlands acquires additional contract rights in the future, it could come back and it could either infill drill on a leasehold basis, seek wellbore location exceptions, which are routinely granted by the commission. But there's no present need for these units. Highlands has represented on its website for many months that it's already completed the terms of farm out agreements, and it's got these 3 1,280 acre units. It needs the commission to make that accurate. And all of these arguments that Highlands has made today regarding stacked units, additional surface impacts, all that is premised on this proposal of stacked and 20 that Renegade has never made. They can still drill minimized surface locations without a drilling and spacing unit. There's no need to have a drilling and spacing unit to have a multi-well pad. And all of these arguments are really irrelevant to the issue before the commission. That it's asking the commission to remedy its poor contracting decisions. So it can, as we heard from Mr. Candace, to raise additional capital. That's its goal. But that's not the commission's role. The commission is not here to be putting its thumb on business negotiations. And what the commission would be really doing here is would be setting a policy to establish best development practices in the drilling and spacing unit. And that's not this commission's role either. So what we really have here is the role of the commission in establishing drilling and spacing units. While this commission has the authority to do so, it doesn't have to do it. There needs to be a compelling need. And the commission's statutory charge is clear here, that it may establish these units to prevent waste, to protect relative rights, to avoid drilling unnecessary wells. And the act is clear that such drilling units were intended to prevent the ills of rural capture. We're not dealing with any of those issues here. Highlands entered into a farm out with ConocoPhillips covering 31 and 34. Highlands also entered into a farm out with Renegade covering 32 and 33. And that all I gave them was the right to drill 1 well in these application lands. And it's this contractual gap that Highlands is asking you to cure here. Commissioner Benton, in January of 2017, you stated that you'd always been concerned about drilling and spacing units being proposed in an effort to do a land grab, or to put something together where you can essentially increase the value of your acreage for the purposes of selling it as opposed to actually drilling wells. We don't know if Highlands actually intends to drill any wells. Maybe they drill 1 well, they prove it up, and they turn around and sell it. Clearly, they're interested in raising capital. Whatever their goals, it's clear that the immediate intent is to utilize this application for spacing and the commission as a conduit to correct and cure its public representations. Highlands is not here today because it has no ability to develop and protect its rights under its contracts. Without any commission order, Highlands may drill 1 well on Renegade's acreage pursuant to the farm out. Without any additional commission order, Highlands may drill a well on a drilling and spacing unit established by order 535612 on sections 34 and 35. And that being the case, the commission must consider the relative effects of the outcome of approval of Highlands applications versus denial of the applications and maintenance of the status quo. As the commission has already noted today, if approved, the commission has assumed that the part of which it seeks to avoid to act as a mechanism for marketing and fundraising for a company that's in the building phase. No relation to actual development. If the application is denied, however, and the status quo is maintained, then all these parties get the deal that they originally bargained for. Highlands still can develop on its contractual rights, and the lands may ultimately be developed in an organized manner. There's no reason that without the spacing, that these lands can't be drilled with additional units, be it a 960, a 480. There's a number of different options to develop, and as Renegade testified, they own the acreage to the north. They could develop with 2-mile wells going the north half of sections 32 and 33 on up north. Now, the Act grants this commission plenary authority to balance these interests. It also has the authority to stop an operator from advancing its own interests when it would come at the unacceptable expense of another party. And that's this case before the commission today. If the commission feels uncomfortable with the position that it's been put in, it should. Numerous aspects of Highlands applications fall outside the authority and the statutory charge of this commission. And in such cases, the commission has traditionally taken a conservative route. In the present case, the conservative route would be to refrain from siding with either party. Just deny the application and allow these parties to go out and resolve their private contractual dispute between them. If the commission is inclined to establish a unit, it should follow Renegade's compromise. It respects both parties' needs. And while there's some discussion about whether or not well-bore spacing units can be used outside of GWAP, we're not talking about overlapping drilling and spacing units. We're talking about one drilling and spacing unit that can be enlarged. In fact, in January of 2017, Director LaPorte even noted that horizontal well-bore spacing units, which are similar in shape, so conceptually to Renegade's compromised 328 units, may be the perfect solution in a given context. And this is that given context. And so for these reasons, Renegade respectfully requests that the commission either deny these applications or in the alternative to establish the Renegade's proposed compromised 328 units in the south half of sections 31 and 32, and the south half of sections 33 and 34, which would prevent waste and protect all. Thank you.
I would assume, Mr. Parrott, that you would like to have some time. How much time does he have, Mr. Brown?
Mr. Parrott has 2 minutes and 8 seconds.
Go.
So first of all, commissioners, thank you very much for your patience and your endurance throughout this day and our hearing. I can't tell you enough how much we recognize that you have a difficult job to do. And I also would respectfully remind the commissioners that over the past few years, you have consistently approved applications basically where one party is proposing to develop and the other party is just wanting to stop development. It happened with Cub Creek, where you approved a 320 acre unit. It happened with Bonanza Creek. It happened with actually ConocoPhillips, which Renegade protested. So Highlands has absolutely met its burden of proof, in large part with testimony to which Renegade actually stipulated. And Commissioner Boygan, I believe you used the phrase bootstrapping their way into acreage. Well, it may be true that Highlands does not have the original lease from the state, but it absolutely has rights to drill, and it has a rig out there. And in the alternative, we have 2 parties, ConocoPhillips, who has not drilled a horizontal well. We have Renegade, who has never drilled a horizontal well, never approved any plan for these application lands, versus Highlands, who has a plan to go forward and is eagerly wanting to develop. And when you are faced with that situation, if you recall that sort of all other factors being equal, if the party who is first to file brings you a plan to develop, that's your policy to approve that plan. And I just leave you with this note. Staff supports this plan. Having sat through many more hours of pre-hearing conferences and reading briefs and all that, staff approves this plan.
And we respectfully ask you to agree with staff and approve our applications today. Thank you.
Any questions from commissioners? I do have one. I was advice of council to go ahead and ask this question. By the way, thanks for bringing up the comment. It's nothing like dragging things out and beating you over the head with it. The question came out when I was thinking about it, is that, and why I asked about Highlands and where they would go with respect to their farm out agreement, so that you would earn a wellbore interest. And I believe that. So my question is that if you earn a wellbore interest, does that give you the ability to force pool the acreage? Because it sounded like the next step is the only thing you have in Renegade right now is to go drill a well. And then you're going to have to either get them to agree to pool it, or you have to go through forced pooling. So my question is if you only earn a wellbore interest from Conoco, then do you have forced pooling rights? Because you really don't have a mineral interest in either the Conoco acreage or the Renegade acreage.
Absolutely, and thank you so much for giving us the opportunity to talk about that. As you know, it is actually not Highlands that would be doing the compulsory pooling. It is actually the commission. And if the commission believes that it is in the best interest of fostering development and producing minerals in an environmentally and surface-friendly way, then absolutely the commission has the authority to pool these lands on its own motion or on the motion of any interested party. And the only thing that is required for standing to bring a pooling application is any ownership interest in the minerals. And certainly the right to drill wells, which gives us the standing to be here today, is a greater right than simply a non-operating right to, ownership interest in the minerals themselves. So we could not only bring the application, but the commission absolutely could approve the application, or the state could bring the application, or Conoco or Renegade could bring the application, or the commission could do it on its own.
Thank you. Any further questions? I'd say the following motion and good cause shown, serve rebuttal by protestant.
There's no time.
Everybody's out of time. I think you ran out of time, so I was going to say that you're out of time. So I guess if there's no other questions, we'll go ahead and close the record and begin deliberations. I have to look at somebody.
I know. Well, I am torn because I see the benefits of efficient development and a similarity in a 1,280 acre spacing unit that we can create many times in GWA. And so there's a lot of reasons why we could approve the application. However, we do a lot of approval on the consent agenda of these larger units. But we have an owner that owns half of the land that doesn't really want that done. So, I have some reservation as well as, why should I create a 1,280 acre spacing unit if an owner of 640 acres doesn't want it? So I don't have a good answer. I'm just torn right now.
Okay, now go. I would have a question for staff, but staff's gone, except for very opposite. You're the remaining staff, and the question would be, once we create a DSU, can we uncreate it? Under what circumstances? If wells are not drilled, can we, on our own motion or by a motion of the party, dissolve it?
Yes. A spacing unit can be vacated at any time, it's particularly where a well has been drilled. So if it's established and you know, 6 months from now, the party has to drill either on our own motion or another party to be vested. And we've done that before.
Thanks, that's helpful. So from my point of view, in addition to the provisions relating to the formation of units and protection of correlative rights, we have to go back to our basic function of promoting the development of the resource, consistent, of course, with protection of the environment, public health, safety, and welfare. And here we've got a well proposal. We've got representations to us that additional proposals are to come. We have an increased density application. We have a farmer agreement with the clock ticking. So we have momentum toward drilling wells on the one side, and on the other side, we don't really have anything other than we would like to do things differently. It's entirely possible, as Renegade says, that no wells will actually get drilled. And that's what prompted my question. But it seems to me we've got a proposal. It seems to conform to our requirements. Wells are likely to get drilled. This is an exploratory area. There's not a lot of development immediately around it. It's in the interests of the state to develop that resource. And so I come out, as I said before, I did use the term bootstrap, and I guess you could say that's a pejorative term, but it's sort of, you have to admire it too. I mean, if you've got the strategy and you figure out how to do it, you know, good on you. I mean, if the rules provide it and you're not being abusive, that's what our rules call for. So it's just, I keep coming back to me, this is a contractual dispute. And I can't see a basis for denying the application. So I would be in favor of approving it.
I think the 1280 spacing makes good sense. Fosters development as well. It doesn't appear that there is a momentum. I'm not crazy about the tactics being employed here, but it's a contractual dispute, I think. So I don't see a reason to deny it.
I think it was fair to bring that up about my concerns about a land grab. I think in this case, though, we do have an operator who has rig in the area, has shown activity and has been drilling. My question is, if we deny this, then what happens if we deny it? We have to go back to the drawing board, then can't get kicked down the road with some of their momentum and ability to drill. So I'm just listening to everyone's comments at this point. I appreciate that.
I think this is interesting, and I was particularly interested to hear the cross-examination and the questions that we asked of Renegade, that the objection isn't necessarily so much to the spacing application as the things that flow from the spacing application. And I think the phrase momentum is really apt, that once a spacing application is granted, there's a lot of stuff that just kind of flows from that. And this is not a new conversation that we've been having. It's a different context than I feel like we've had it. I'm thinking back to the last meeting. But I think there are lots of people who are opposed to spacing applications because they see that there's a variety of other actions that then flow from that. And there might be direction of, well, that's more of a pooling issue, or well, that's more of a 2A issue, or more of a 2 issue. But the fact of the matter is, once the ball gets rolling, it's really hard to stop. So that, I think, is my overarching concern, that I think that granting the application is in line with the way that spacing applications are typically treated. I think that it's consistent with the burdens that we typically place on applicants and the things that we resolve on the consent agenda. However, I do think there are legitimate issues about when and where parties can engage effectively to raise issues. Where is the right time? If it's not spacing, is it really possible to stop the ball, I guess, at the later stages? And that's something that I think I would hope that this commission could have more discussion about.
So the way I look at it, I feel like Highlands' application for an exploratory drilling program makes sense. I see that they follow our requirements and our rules. I think they've proven here that, or given testimony today, that they prevent, if that plan prevents waste and protects corrosive rights. And as most of my fellow commissioners have said, they presented a development plan. I think we didn't do a great job of staying out of the weeds today. And this contractual issue took up a lot of time. And if you take that out of what we're looking at today, we really are kind of back to what we looked at in the past. And here's my plan and here's your plan. Or here's my plan and here's my other party's plan, and which one is better? And I think in the past, we've tried not to rule too much on which one is necessarily better, as long as the one that's been submitted is adequate and provides the right evidence that we tend to rule in that favor. So I would rule in favor of the word today.
Would you like to put that in the form of a motion? I'm sorry, Commissioner Holton, I forgot, Commissioner Holton. He must have had something else happen. Okay. So at this point, back to you.
So, Mr. Rancy, I need to do all four separately?
No, I think you can combine them in one.
Okay, I'll try to combine them in one. So I move for approval of docket numbers 161000415 and 161000416, which establishes the 1280 acre exploratory drilling and spacing units, as well as approval of dockets 170500204 and 205 that authorize the additional 3 wells in each of those DSUs.
I didn't want to stop you, you're on a roll. That's good. I think if you are so inclined, if the commission is so inclined, you can also simply move to adopt the hearing officer's recommendation.
That would be a lot simpler.
And just as amended, as I stated on the record earlier.
Right. If we vacated the 1280 and this establishes a new one in 416. Okay. There's been a motion made to accept the hearing officer's recommendations.
I'll second it.
Second, any further discussion?
I'll just make a point that, not as part of the motion, that we need to continue to look at it and see if wells are drilled or not. And if they're not, I would want staff to take another look.
Good point.
And I would say, just in terms of discussion before we take a vote, that I think I ultimately support the motion, but I want to state that, at least for me personally, that that I'm interested in taking a hard look at each stage and not simply granting subsequent requests because we granted direct requests.
Fair enough. I think we as a commission, we have a record of taking each one as it comes. All right. So we have a vote. All in favor, signify by saying aye.
Aye.
Opposed, same sign. Motion passes. Yes, sir. Okay. I think it's been a long day.
Thank you.
Thank you all for your time.
Thank you very much.
Down here, we do appreciate it. That, I guess, we'll adjourn.